The Partnership Limited is a joint stock company. It has a perfect patrimonial autonomy and a legal personality. It has another feature that reminds the simple limited partnership that it is a society of people. It is uncommon the distinction between general partners and limited partners. General partners are liable without limitation jointly and several for social debts, and unlike the limited partnership, are always administrator. Limited partners are liable to social debts only within the limits of the share of the subscribed capital. In the name of the company must indicate the name of at least one general partner and the initial of the company. Partnership limited by share is not very common as a type of company. The rules that apply to the partnership are the rules relating to the joint stock company. First of all, it is mandatory to register with the business register, otherwise it cannot exist as a company. There are various types of shares such as saving shares and the ordinary shares. The circulation of the shares can be to the bearer, therefore they can be simply delivered, or nominative. The endorsement is necessary so they can be yielded. There are three necessary bodies of the company: the shareholders meeting or the assembly, the board of directors, and the board of auditors. The annual account must be drawn up and there is a liquidation. In the companies of capital, there is another type of company, the limited liability company. There are some differences as well between this one and the joint stock company. The first one is the minimum capital for the company to exist. In a limited liability company, a minimum capital of 10,000 euros is required, which are represented by the participation shares. For the joint stock company is 50,000 euros that are represented by shares. Another difference are the shareholdings or the partner in the company. In the limited company, the members are very important and actively participate in the life of the company. This doesn't happen in the joint stock company because the shareholders or the partners are interested in the final result and do not participate in the management decisions. Even the supervisory body is not the same. For the limited company, the board of statutory auditors is not mandatory because the organization is more flexible and simple. It is suitable for entrepreneurs who don't want to risk their personal asset and who want to avoid the bureaucratic complexities of the joint stock company. In the joint stock company, the board of statutory auditors is compulsory. It is suitable for entrepreneurs who want to start a large business and want to accumulate large capital. The assembly is also different. In the limited company, the convocation of the meeting is simply communicated. In the joint stock company must publish in the Gazette Ufficiale 15 days before the meeting the notice of convocation with ordine del giorno, which indicates the topics plus the time, the day, and the place. The financial statements are a document drawn up at the end of an administrative period where it presents the financial statement in a summary of the assets and liabilities. It is an instrument of control of the administrative bodies, but also a management information tool where quantitative and qualitative data processed by the company system are collected. But why does the law require all commercial entrepreneurs to submit a balance sheet at the end of the year? This is because it's the main tool for both members and third parties or the stakeholders, so they can realize the state of health, how reliable the company is. The financial statement consists of the four parts. The first one is the balance sheet that has two opposing sections. The left section records the assets, the right section records the liabilities. The second part is the income statement that is drawn up in a scalar form where the income earned and the costs incurred are disclosed. The third part is the financial statement, where a statement of both positive and negative cash changes. And the last one is the notes to the financial statement, providing additional information.
A cooperative. A cooperative is a business organization owned and operated by a group of individuals for their mutual benefit. The cooperative society is recognized and protected by the Constitution in the Article 45 of the Constitution. The cooperative society is a variable capital company in the sense that the share capital is not determined in a defined amount, but is precisely variable, so as to allow the free entry and the free exit of the members. The Civil Code recognizes the variability of the capital as a peculiar element of the corporate societies, has not indicated a minimum value to be subscribed, but has fixed that the minimum value of the per capita share is €25. Unlike other capital companies, the cooperative society operates as an enterprise consisting mostly of natural people who work for the satisfaction of their economic, social, and cultural needs through a jointly owned company managed in a democratic way. In the meeting, in fact, the members do not vote on the basis of the subscribed capital, but per head. That is, each member has only one vote, except in special cases. The cooperatives have as their common purpose not the profit, but a mutualist purpose, consisting in satisfaction of the interests of the members from the performance of their activity. Therefore, we can say that cooperatives are formed to directly favor the members through the production of goods and services produced directly to them and on more favorable conditions than those usually found on the market. The regulatory models to which cooperative societies refer are that of the S.p.A. and S.r.l. The choice of one and the other legal models depends on cooperative society with less than 9 members and with assets of less than €1,000,000 must choose the model of S.r.l. Cooperative society with at least 20 members and a capital asset of more than €1,000,000 must choose the S.p.A. model. Cooperative societies that do not exceed both pyramids and or are not lower than both pyramids, the members at the time of incorporation have freedom of choice between S.r.l. and S.p.A. The cooperative society can only be constituted by public deed, so it's necessary to contact a notary, who will then send the documentation to the court within 30 days of the deed stipulation. If the documentation is complete, the company will be registered in the commercial register, which is held by the Chamber of Commerce. A very important element is the statute, that has the fundamental function that of determining the general rules that society must follow, indicating the following elements. Subsequently, the cooperative society must be registered in the Register of Corporate Entities. The registration in the Register of Cooperative Societies is provided for by Article 15 of Legislative Decree number 220 of the 2nd August 2002. It has a constitutive character. This means that the registration in the register is an essential element for the purpose of mutual qualification. In the absence of registration in the register, the cooperative society is not considered as such and cannot benefit from the facilities provided. There is a different type of cooperative society, that is corporate society with limited responsibility, in which the members have a limited social responsibility towards the company. Responsibility refers only to the assets conferred in the company. However, limited responsibility applies only to small cooperatives. Cooperative societies consisting of 9 or more members must always have unlimited responsibility. There are various types of cooperatives with prevailing mutuality. Cooperative society can be distinguished according to the purpose they pursue through their activity. They can be grouped in 3 groups. We have consumer cooperatives or services, cooperatives of production and work, and cooperatives for the contribution of goods and services. From these 2 groups, we can identify different types of cooperatives, in which consumer cooperatives, which aim to provide its members, that are its consumers, goods and more advantageous price that those operated by the market. They have developed mainly in the food sector. The advantage depends on the fact that the members, through the cooperative, make joint purchases, obtain better purchase condition, and the cooperative sells the product directly at more competitive prices without involving other intermediaries. One of the most important consumer cooperatives is CONAD. Acronym stands for Consorzio Nazionale Taglianti, that is one of the largest organizations of independent retail entrepreneurs present in Italy. In 2019, they have been the first chain in the large-scale organized distribution. On May 13, 1962, the Consorzio Nazionale Taglianti was born, a cooperative with limited responsibility to bring together under a single name a group of small retailers driven by the desire to emancipate themselves from the power of wholesalers and the brand industry. Shortly after, the first supermarket opens in Bologna, the only example of neighborhood center in Italy, managed by a company that brought together 7 merchants. In 60 years of history, they have grown so much to the point of winning the market leadership in Italy, thanks to their being movement and system, combining social commitment and economic growth. and fully realizing their ambitious vision to be an organization of independent retail entrepreneurs that best meets the expectation of customers and that has a primary economic and social role in the communities in which it operates. Mauro Lusetti is the president of Conad. He was elected president on May 9, 2023. His professional career began in 1974 in Lega Coop Modena, landing in 1980 at the Associate Conad Mercurio Modenese with the responsibility for the development of the sales network and the relationship with the members. Over the years, as head of the organization, he has held numerous positions in the society world, president of the Alliance of Italian Cooperatives, advisor to the National Council of Economics and Labor and the Barbierini Foundation, and president of Coop Fund, a fund with 500 million euros of assets intended for the development of cooperation. Then we have the production and employment cooperatives. They offer to the member job opportunities with better conditions than they would find on the market. Production and labor cooperatives are aimed at placing the worker or products of members in better condition and at providing direct and immediate benefits to the economy of individual members. Then we have agriculture cooperatives. There is no definition of agriculture cooperatives. However, from Article 2135 of the Civil Code, there is a notion about agricultural entrepreneur that infer that those cooperatives that perform cultivation of land and forestry, the rearing of animals with fed obtainable for at least a quarter from the ground and activity directed to the production of plants to the use of structures, then activity aimed at the handling, processing and disposal of agricultural livestock products, and the activity relating to the provision of services and to agriculture members. Then we have transport cooperatives. They are responsible for providing logistics services. Then social cooperatives. They provide social and health services, education, or activities aimed at helping people in difficulty to enter the world of work. Then construction cooperatives. Building cooperatives are intended to associate people to ensure them to purchase of a home owned or rented. These type of cooperatives have the object of being able to provide accommodation direct to the members, differentiating themselves from the production and the work cooperatives in the construction sector. Then we have cooperative credit banks. They pursue social utility purpose and provide credit primarily to their members,